acceptance. Each side will have 20 minutes in which to argue its appeal. The appellant may reserve a portion of that time for rebuttal argument, counsel, but you'll need to keep track of that time for yourself. We've conferenced this case. We're familiar with the facts and issues raised here. Would each of you identify yourself and the party you represent as you begin your argument? Counsel for appellant may proceed.
Good morning, Your Honors. May it please the Court. My name is Mark Sifferman, counsel for the appellant. With me at counsel table is co-counsel David Knapper. Our argument is very simple. Our client, we believe, the appellant, had the right to redeem from this mortgage foreclosure pursuant to 12-1283, which is a statute that specifically grants the right of redemption from the foreclosure sale of a mortgage or a foreclosure sale of any other lien. That statute gives the right to creditors having liens upon the premises sold.
Keep going.
So
we're just making sure we had the right statutes in front of us here.
12-1283 is our position. When that was adopted originally in 1913.
This is before at least Judge Thompson was born.
I'm not going to touch that one,
I
Your
won't
Honor.
touch that one either. Okay.
Probably before we all were born. Putting it in the historical context is important because at the same time, Arizona adopted its mortgage statutes.
May I stop you there? I've looked at the 1913 code and in fact traced it back to 1901 and even in earlier territorial days in 1887, which really doesn't apply here. And I didn't quite understand that point, and you had also made that point in your opening brief, because the 1901 statutes, in the 1901 code, we had statutes involving mortgages and mortgage foreclosure. They weren't as elaborate as they are today, but we had some. And in the 1913 code, we also had statutes that involved and concerned mortgages and also foreclosure. Now there were some additions in the 1913 code, but so we always had statutes involving foreclosure. So are you making a slightly more refined point than I'm understanding?
Yes, because what is critical is not only the adoption of what turned out to be 12-1283, but actually what turned out to be 12-1282, because we had the first part of 12-1282 is the same language that was in the 1901 code. But the second part, which talked about everybody other than the judgment debtor, that was greatly expanded. It was totally replaced. The California language that had been there was taken out, and the language from the Minnesota statute was adopted, which was the addition of the legal or equitable, the reference to other liens. And we believe that the purpose of that was to expand the universe of people who could redeem from a mortgage or lien foreclosure sale. Because otherwise, why would you have equitable in there? Except to the extent that you could have equitable liens. And
let me ask you a question that has troubled me about in the 1913 code, section 1376, and that language which has been carried down to today, which is now in 12-1282, and it's now subsection C. And I'm going to refer to the current statute just because it's a little bit easier. Basically it goes, if the redemption is provided in subsections A and B is not made. Okay, so that's new. But here we get to the language that existed back in 1913. The senior creditor having a lien, legal or equitable, upon the premises sold or any part thereof. Here's the language that I'm having a hard time understanding. Subsequent to the judgment under which the sale was made. Okay, are we talking about that these creditors have to have liens that came after the judgment that gave rise to the sheriff's sale?
No,
What does
Your
that
Honor.
mean?
No, Your Honor. I think, what I believe happened is that when you look at 1283,
Right.
it says, here are the people who can redeem and the order in which they get to redeem and the time.
Yeah, right.
And the 6 months and then the 5 day, 5 day, 5 day doesn't require it doesn't have to be subsequent to subsequent to the judgment, but it's that under 1283B, the order and the time follows what is in Section C. So I believe you don't read that subsequent to the judgment on which the sale occurred, but it should be subsequent to the mortgage or lien that was foreclosed.
Well, I agree with you. I think that's probably what they intended. And indeed, if you track back and look at the Minnesota statute that existed in and around this time, it's a little hard to tell which Minnesota statute it was because they varied a little bit too, and the reference here is a little vague. But the language in the Minnesota statute said subsequent to the mortgage under which the sale was made. And here, for some reason, our legislature the first legislature after statehood, used the language subsequent to the judgment. I'm not sure it changes anything because you're focusing on the word senior creditor having a lien, legal or equitable, as I understand your argument, as additional support for your interpretation of 1283, which is it means creditors. It's straightforward. It's creditors, creditors, or creditors. This is a creditor having a lien, and a homeowner's assessment lien is in fact a lien. It's straightforward.
Yes, Your Honor, and of course, from going through the Minnesota statutes, it seems to be clear that they kept execution sales and they kept mortgage and lien sales separate and didn't really mix the two. Our legislature cobbled things together, and they first brought in the execution statutes, and they swept in the mortgage statute. But when you get back to statutory construction, if, as the Superior Court found, the only people who are entitled to redeem from any kind of sheriff's sale, be it a judgment lien foreclosure, be it a mortgage foreclosure, be it a mechanics lien foreclosure, the only ones who are entitled to redeem would be those under 1281, which are the judgment debtor and anyone else holding a mortgage or another judgment lien. If that were true, then why would we have 1283? There wouldn't be any reason for it.
Let me ask you about this. The issue in this case is whether, as we know, is whether a holder of a homeowner's assessment lien can redeem. And your argument is, or your client's argument is principally based on 1283. So let's assume for the moment we agree with you that under the clear and plain language of 1283, that when you have a mortgage foreclosure sale, following that, a creditor, and there's no limiting language, so any creditor having a lien can redeem. That's following a foreclosure sale. What then happens when we are dealing with a true execution sale following, let's say, a general money judgment? Does that mean then that under 1281, the universe of redeeming creditors is limited? Is limited to basically creditors having a lien by judgment or mortgage? My point is that there will be a different universe when you're following a foreclosure sale of redeeming parties, and the universe will be then different when you're dealing with just general execution or other forms of sales that are not sales following a foreclosure. Is that what we end up with?
Your Honor, I believe that's the result you have to reach. Otherwise, you would do violence to 1281.
Does that seem sensible?
Well, thinking through that this morning, actually. In the practical world, it probably doesn't make any sense. It probably doesn't make any difference, because if you think about who would exist junior to a judgment lien being foreclosed, very unlikely there would be, there might be, and the statute talks about mortgages, reading the old cases, apparently people got a lot of mortgages granted to them even though they had judgment liens on their property.
I know, isn't that amazing?
That is amazing.
A different day, yeah, okay.
But there shouldn't be, if someone is foreclosing a judgment lien on a money judgment, they want to be taking it free and clear of other liens, and there shouldn't be anybody junior to them.
Well, there could
Hardly
be
that there would be
if I'm a debtor, and I borrow money, and I don't pay it back, but I've also have other, let me think, I have,
The situation
Well,
arises in the family law
Good example,
where
yeah.
a parent or other relative might loan a couple of dollars to try to help them out, knowing they're junior, and can, see it as a potential opportunity if they otherwise have the money and can keep continuing to help the kids.
well, or suppose we have a homeowner's assessment lien, but there has not been a foreclosure. Does that mean then, under 1281, a holder of a homeowner's assessment lien, clearly not a creditor having a lien by judgment, and it's not a mortgage, that person would not fall within the redeeming group, the parties able to redeem under 1281?
I think that's the result you have to reach with considering the language of the statute, whether it makes any sense. I think you're right. It doesn't really make much sense, but it does. It's what the statute says.
Do we even get to any of this based on the Western Land case?
Actually, Your Honor, I think Western Land actually solves the issue, and it's at the end of page 275 of 28 Arizona Reporter. In that case, the appellant had an attachment lien, also had a mortgage. Another lender had a mortgage, they foreclosed. There's a sale. And the issue presented was, what the court says is, the appellant, because they have attachment lien, has the right to redeem under what was 1377, under the 1913 code, which is now 1283. And then he said, but the issue is, what happens because they foreclosed their mortgage? And they go into analysis, and at the end of the opinion, they come around and say, the appellant's not entitled to redeem under the mortgage, but they are entitled to redeem under the attachment lien. Yes, it answers the question, Your Honor.
What about the bank's argument that, well, yeah, but there was a judgment in that case. The holder of the attachment lien had obtained a judgment.
The 1281 talks about a lien by judgment. A lien by attachment doesn't occur on the judgment, it occurs on the levy by the sheriff under 12-1532. So it doesn't give them any more rights because they got a judgment. Judgment lien is a lien created on real property when someone records a money judgment.
Well, also, didn't the court in Western also explain that the attachment lien would be superior to the, I guess it would be the appellant, anyway, the holder of the third mortgage. The third mortgage would follow. The holder of the third mortgage had redemption rights, but they would follow. They were junior to the holder of the attachment lien.
Correct.
Okay.
I'd like to reserve the rest of my time, Your Honor, to respond.
Thank you, Counsel.
Good morning, Your Honors. May it please the Court, my name is Kim Lepore. I am the attorney for the appellee, the Bank of New York Mellon Trust Company, as trustee. As you know, Your Honors, this Court is about statutory interpretation, specifically whether a non-judgment, non-mortgage creditor is entitled to redeem. We believe the Arizona redemption statutes clearly prohibit this. As you know, the statutes related to the same subject matter are supposed to be read together or in pari materia to give effect to the statutory intent and to maintain harmony. We believe that reading the statutes in our position, as stated in our brief, gives that harmony, that effect of the harmony. The first statute, 12-1281, provides who can redeem. The second statute, 12-1282, provides the timing. It specifically says timing of when the redemption can occur. And 12-1283 provides when the redemption should occur after a foreclosure sale, a mortgage foreclosure sale.
You know, we have both by statute and case law a rule of construction that says titles and headings of statutes are really not dispositive. So let's strip away the titles of these statutes.
I do understand that, Your Honor. However, there is case law that says where ambiguity exists, the title may be used to aid in the interpretation of the statute.
Well, in looking at the evolution of these statutes, what I noted is that the titles did not come into existence until I think it was around, I think it is the 1939 codification. So none of these statutes had title, but yet they existed basically as of about 1913. They existed in the format that they currently exist. So the titles were added well after their initial adoption by our state legislature. So I'm not finding the title argument real persuasive. The other thing I noted is that when you go back and look at the 1901 code that gave rise to some of this, when the section that is now 1282 was adopted, that was specified in the title, if we want to go back to titles, in the titles used in the 1901 code as describing who were the parties entitled to redeem. So they didn't ascribe that. The code commissioner who basically drafted our code, if he wanted to use titles, he didn't even use the title as identifying who can redeem under what was then in the 1901 code, what is now, 1281. So, I mean, titles are not real persuasive here.
I agree with Your Honor, and actually, in the civil codes of 1901 and 1903, it specifically says redemption shall be made only by the following persons. Mm-hmm. However, it's significant that in 1913, in the same year that the legislature enacted 12-1283, the legislature took out those words. They took out those words, and they did not add those words to 12-1283. We can assume by the legislative's their specific actions that they intended that 12-1281 would say who's entitled for all of the statutes. They didn't need to add anything additional as any additional parties who are entitled to redeem. If you read 12-1283 the way the appellant would have you read, it would give no effect to 12-1281.
Well, they make the same argument. I mean, I understand the point, but Mr. Schifferman, you all are making the exact same argument. You're just starting from a different perspective. You start from 12-1281, and the holder of the assessment lien here starts from 12-1283. And the reality is, let's be clear and really candid, these statutes are kind of a mash of mess. And they use all sorts of terminology, a lot of which is not consistent. In some were creditors, and others were lien creditors, or creditors having liens by judgment. Then sometimes were called redemptors in the older statutes. I mean, there's a whole variety of characterizations. But what is clear is that what is now 1283 came into the statutes in 1913. And what I also noted that in 1913, the foreclosure statutes were amended to add in a particular specific provision that required, first off, it required all mortgages now to be foreclosed through a judicial action. And it then provided additional directives as to what would happen when a mortgage is foreclosed. So there was a lot more specificity about mortgage foreclosures. And at the same time, the legislature adopted what is now 1283. It does suggest to me that they were focused on what should happen following a mortgage foreclosure and who should be entitled to redeem. And they were focused on that. So in that sense, that's the more specific set of statutes that would generally apply to this particular situation.
Your Honor, I agree partially. First of all, in 12-1281, it specifically says who can apply. It says creditors having a lien by judgment. As you noted, the rest of the statutes is kind of loose, and it says subsequent lien holders. And in fact, most of the cases, they use creditors having a lien, junior lien holders, subsequent lien holders. However, you have that specific language in 12-1281. And case law also says that when you have specific versus general, that you need to go with the specific.
But why is that specific? Why isn't that general versus 1283 that deals specifically with proceedings following a foreclosure of a mortgage, then combined with the additional language that was added in 1913 that the legislature made it really clear that now all mortgages have to be foreclosed by a judicial action, because at least as I read the statutes, at least prior to 1901, mortgages could be foreclosed both through a judicial proceeding and through the exercise of a power of sale if it was reserved in the mortgage. So, I mean, in 1913, the legislature really said, no, we're not going to allow these other mechanisms.
Your Honor, that's a good point.
Yeah.
And I also believe that is why 12-1283 was put into place, is because at the same exact time, the courts were elaborating on the foreclosure rules and the foreclosure statutes. And I believe that the legislature wanted to clarify that these redemption times in 12-1282 also applies to sales after mortgages. In 12, this is from the express words of 12-1282, it talks about judgment under which the sale was made, which would imply that it's some kind of judgment other than a mortgage. And in 1283, it specifically says after a mortgage foreclosure. So I believe that the legislature clarified it. It's important to note that at that same time this was enacted, they did not modify 1281. They didn't say additional parties who can redeem. They didn't add .01 that says additional parties like they did in the definition of forcible detainers in 12-1137. And they didn't specify in 12-1283 that these are in addition to the parties entitled to redeem in 12-1281. I believe the legislature just meant to clarify, since everyone was in an uproar about these mortgage statutes, is that the same timing applies. It should also be noted that 12-1283 does relate to the timing. It doesn't necessarily say who can do it. It just clarifies that the same periods shall be allowed.
Well, that's true as to subsection A, which was in fact the very first sentence of what was in the 1913 code, section 1377. But then we have subsection B, which was also in the 1913 code. It's like, I believe it was essentially the second sentence. And that has nothing to do with timing.
Well, it does say they may be redeemed within the times and in the order specified in 12-1282.
Well, excuse me, you're absolutely right about that. But then it goes on to say, if no redemption is made, creditors having liens upon blah, blah, blah. So if in fact A discusses timing, what, pray tell, would be the point of saying it again in subsection B? You don't need that. So what's the point of B?
Well, that's a good question, Your Honor, but the first one says, frankly, It clarifies that that's sales after foreclosure by mortgages, that they have the same timeline, and it clarifies that the creditors having a lien afterwards also have the same timeline. The debtors, the mortgagors have the same timeline, and the creditors have the same timeline. However, it's still...
But subsection A, forgive me, it's as if we all could go down the street and help our legislature rewrite these. It would be a useful exercise, perhaps. But A says sales upon foreclosure mortgages or other liens. I mean, it's kind of like, what is it? They decide to say it twice?
It does say or other liens, and you can't, it could be in, I have no idea.
Yeah, well,
I really-
understand. No.
I
Well,
can't-
it would seem in terms of the common sense is that if you have a lien junior to the one that's being foreclosed, you get 5 days to attempt to redeem if you can in order to protect your interest and pay off the judgment. And if you can, good. And if you can't, you are foreclosed and you lose, protection of the property. And then your only recourse is going after the debtor on the note. Kind of what happens on a deed of trust, on a trustee sale. Unless you come forward at the sale, you're hosed.
Could you
That's
go
a
back,
judicial term.
go back to 1282 and explain to me how you believe subsection C operates? And let's not get bogged down about the A and the B section. I mean, I understand 6 months and then how that works, but I'm starting with the senior creditor having a lien, legal or equitable, upon the premises sold or any part thereof, subsequent to the judgment under which the sale was made. How do you interpret that language? You mentioned it a little bit a moment ago, and I want to make sure I have it.
Because mortgages didn't have to be reduced to judgments to be foreclosed prior to this time, this section probably was intended just to say what any judgment, an execution under any type of judgment that someone had, including an attachment lien.
So would that mean then that the lien would have to be literally subsequent to, which is poor grammar or just poor writing, means after the judgment? So the lien would have to arise after the judgment?
After the judgment that was foreclosed, so in lien priority, say the first, whoever obtained the judgment first in time, that one forecloses. So anyone with subsequent ones, they're entitled to redeem. If it was above, whoever purchased it would take it subject to them. So yes, it is subsequent to the one that was foreclosed.
Okay. Well, I'm sure you're going to get to this. Tell us about how we, as an intermediate court of appeals, we decide that Western doesn't really resolve the issue here.
Yes, Western does not resolve the issue in appellant's favor. I believe it does resolve the issue in my client's favor. In Western, it's very clear that the attachment lien was reduced to judgment.
Well, that is absolutely correct if you read all three of the Western cases. There's no question about that. It was foreclosed. But in the principal decision that we're discussing, that's in volume 28 of the Arizona Reporter, the court made it clear that the second creditor, who had the second mortgage, could not redeem based on his second mortgage, because that basically he had lost that mortgage. But that he could redeem because he held an attachment lien. And the court made it clear that that lien, as an attachment lien, which Mr. Schifferman is correct, it comes into being as of the date of the attachment levy, was senior to the third mortgage. Otherwise, if that was not the case, the court would have stated that the holder of the third mortgage was senior to the attachment lien. And that the court didn't say it. So it has to be the attachment lien is both senior to the third mortgage and also entitled the holder of that attachment lien to redeem.
You're saying because of the dates. You're saying that the attachment lien was before the third mortgage,
Yes,
but the
absolutely.
judgment wasn't until after the third mortgage.
That's right.
I understand
That's
that, and maybe
yeah.
the legislature thought there was, or the court thought there was some relation back. However, this issue was not specifically decided by the court in this.
Well, I grant you that it is perhaps not the pivotal issue. Nevertheless, it is at best dicta from our Supreme Court, and we have quite a bit of case law that basically says we are not in a position to ignore Supreme Court dicta.
No matter how old it may be.
Yeah, even older than the three of us.
Your Honor, I don't even know if this is dicta, though.
Then what is it when they say very clearly that the court clearly holds that the second creditor may redeem based on his attachment lien, not based on the mortgage, which the court explains has now, I'm going to use the word evaporated because he foreclosed it, but based simply on the attachment lien, and that he can redeem. That really is a central holding of that case, or an essential point in the case. Maybe not the holding, but a central point in that case.
I do see that, Your Honor. However, it appears that the parties stipulated as such.
Show me where they stipulated.
Well, the parties,
I have the case, so if you can point me.
I'm looking at
Okay.
at it, Your Honor.
It's clear that the
parties
holder of the
admitted.
second and third agreed that the holder of the first mortgage was senior no matter what. So they clearly stipulated as to that. And the holder of the third mortgage clearly stipulated that the second mortgage was senior. But other than that, I don't see any stipulations that would bear on the point we're discussing.
Well, it says that it's admitted by the appellee.
Well, yeah, because, yes, it was. It was admitted, but the court goes on to reason on its own. It was admitted by the appellee that this judgment must be reversed by virtue of the decision in the homeowner's the homeowner contested, as I recall, the foreclosure judgment of the attachment lien. And there was an argument about abatement or something, as I recall. And while this Western case was pending, the Supreme Court decided that appeal. So now we know that the attachment lien is in fact valid. So that's the only thing that happened. And so you're right, the third creditor, or the holder of the third mortgage, agreed, yeah, okay, the attachment lien is valid. And then the court then went on to explain what was the impact of that attachment lien in this particular case.
Your Honor, I can tell you that there's a difference in our case, regardless, is that the HOA or their successor in interest did not get a judgment. So perhaps the attachment lien was a placeholder, and once it was reduced...
It can't be. Mr. Sifferman is right. The attachment lien begins, even under the 1913 statutes, which is also true today, because this was a prejudgment attachment lien. The lien exists as of the date of the levy. And that was the important point, not the date of the foreclosure judgment, but the date of the levy. And indeed, our cases also recognize, even back before 1913, that the lien continues to exist. It goes forward, even after a judgment is entered, until the property is actually finally sold.
I don't know how to differentiate that case or why they held that the attachment lien was prior to the third mortgage. I just know that the case is different here. It was not reduced to judgment, and that's the sole purpose of this redemption statute, which I wanted to get to real quick, is the policy part. The policy or the purpose behind the redemption statutes is to increase bidding, and as we stated in our statute, if anyone was allowed to redeem, there would be no competitive bidding. It would significantly
I didn't follow
decrease.
that because, frankly, you weren't there, and I'm sure you didn't strategize with the bank's representative about making the lowball $22,000 bid for this property. But you want having more creditors who can redeem. Doesn't that encourage competition?
I don't believe so, because they use this wait-and-see approach. If they are not entitled to redeem, they're more likely to get in there and try and get the property so they can at least recoup some of their debt, some of the debt that's owed. But if they have the right to redeem, they're just going to sit back, exactly as the appellant did in this case. They're going to sit back.
Well,
Bidding
isn't that
will
the
be
danger?
low.
If you're in the list of redeeming creditors, and you can't sit back, you either you pay to play. You either pay your money and make a legitimate bid, or you take a pass, and then you take a risk.
Only if it's beneficial to you, as it was in this case. He sat back and waited. He bid up to a certain amount.
Yes, that's right, but your client could have submitted a legitimate bid, and it did not do so.
It could have, Your Honor.
And
but
it should have.
And it doesn't change the results here.
Well, but we're talking about the policy, and the policy is to encourage bidding up the price.
And as I stated, if anyone having a lien can redeem, they don't need to go there and bid at it. They can sit back and wait and see if the numbers make sense to them and decide, okay, you know what, it's not worth it, I'm going to do it. And if everyone did that, sat back and wait, the bidding wouldn't go up.
That cannot be. Because let's say that Judge Thompson is a redeeming creditor, and he is senior to me, and he is, in fact, senior to me. Okay. He bids in, and he pays X amount. When I redeem, I not only have to pay basically I have to pay everything that was in the stream ahead of me. So I'm going to be tacking on what he paid plus what everyone else paid. Forgive me, I know we're out of time. So I'm not getting a free ride. I can't sit back. I'm going to be paying everything that went before me. There are some nuances here, but basically that's how the system works. So I can't sit back and wait. I'm going to be paying it.
But you'd be paying less. If the bidding doesn't increase because people aren't there to bid, it would start at the initial bid, and then later you'd be able to get more for your money. Thank you, Your Honors.
Thank you, counsel.
Your Honor, let me address the public policy argument, because we do have the Arizona Supreme Court decision in Macha versus Watts. Both parties cited at 132 Arizona 378. It says the redemption statutes are remedial and exist for dual purpose: ensuring that property is sold for a fair price, and that if the mortgagor, the debtor, doesn't redeem, the property will be applied to payment of debts in the order to the various creditors. So it's not really saying that the purpose of the redemption statute is to increase the amount of people bidding at the sale. It is that the foreclosing lender, foreclosing lien holder, will be motivated to bid such a price that is closer to fair market value, so that in such a case, usually junior lien holders, junior creditors, it's not economical for them to redeem. But in a case such as this, where there is a low ball bid, then people who are junior under this public policy have the right to look to the real property for repayment of their debts. And let me address real quickly the argument that our interpretation of 1283 renders 1281 inoperative. It doesn't. We say the only way to reconcile these two statutes is to say that 1283 applies to mortgage foreclosure sales and other lien foreclosure sales. 1281 applies to share of sales on execution of judgments. It's the way you can reconcile them. And my co-counsel reminded me that when we were talking about, well, what about a foreclosure of a judgment lien? Why is the universe limited? Aren't we going to wipe out homeowners association liens? he reminded me of the statute actually makes homeowners association liens senior to everybody. So anybody who buys homeowners association property at a judgment foreclosure sale is going to take it subject to the homeowners association lien, as they would have
Saying
taken
that
it.
again, I want to make sure I track that, because I thought the assessment liens, they are senior, except they are junior to basically your first mortgage.
Correct.
Okay, so let's put that aside. So say that, make that point again.
What I'm saying is that the concern that 1281 on a foreclosure of a judgment lien limits the universe of potential redemptors. It doesn't exclude, it doesn't wipe out homeowners associations, because they are not wiped out by the.
You're saying the judgment creditor who holds the lien, the lien creditor, would be junior to the homeowner. And so if they wanted to sell the property, if they wanted, let me start. If the sheriff then sold it at an execution sale and the creditor decided to credit bid his lien in, he'd still have to pay off the homeowners.
Correct, Your Honor.
What then about other lien holders, like Judge Portley was mentioning, the family law context, where they're not given statutory priority?
Well, they would have a mortgage or a deed of trust, which the statute allows them to be.
So they wouldn't be left out in the cold, I
Right.
guess, if they were truly senior.
Right.
Okay.
Thank you, Your Honor.
Thank you, counsel, for your arguments. We'll take the matter under advisement. We'll issue our decision in due course. Court's adjourned.